Hey legal studs! In this video, we're going to show you how to answer a question where you critically analyse and compare courts and VCAT. The last question on the legal studies exam is always worth 10 marks, and in recent years, it has asked students to write about 2 different areas or institutions. Courts and VCAT are examples of institutions that could come together in an exam question for a 10-mark question. Let's look at this sample question. VCAT is a very effective institution for resolving civil disputes. Therefore, we should strip the courts of all their civil jurisdiction and leave all of these matters with VCAT. To what extent do you agree? Now, I think that VCAT is clearly the best institution to deal with disputes. But I can't just write that for my answer, because questions like these ask you to look in a really balanced way at both the positives and negatives of institutions. So I'll need some help answering this question. Amani, can you think of any positives of courts or negatives of VCAT that I could use in my answer?
Oh, can I? What do you think is so good about VCAT anyway?
VCAT keeps its costs really low. In 2014, it only cost $158.90 to make an application to VCAT for a claim under $10,000. Court fees are significantly higher. It's not helpful to have high court fees because we need everyone to access the legal system. Also, you generally need legal representation in court, which means you pay solicitors and barristers' fees. In VCAT, there's no reliance on legal representation, meaning that parties can avoid that fee too.
Legal representation can be necessary though. I don't think we should dismiss the importance of legal representation just because it's expensive. If a party has legal representation, it will help them to present a good case, since the party will have an expert who understands complex laws and legal jargon. The lack of legal representation in VCAT can be a really negative thing. Parties might not understand the law itself, or one party might have a better understanding of the law, and use that to take advantage of the other party.
You've raised some good points, but lack of legal representation is one of the reasons why VCAT is such a quick process. Over 90,000 disputes get resolved by VCAT every year. Disputes heard in VCAT's residential tenancies list take on average 4 weeks from application to completing the hearing. There's a huge backlog in the courts, especially because of the strict rules of procedure and the need for legal representation. VCAT does an amazing job at easing that pressure on the courts.
Yeah, but Tessa, what if we just use VCAT instead of courts, like you're suggesting? All of those complex cases that take ages to be resolved in the courts will suddenly come into the hands of VCAT. VCAT might lack expertise on certain issues. They're complex cases. That's why they're held in courts. There's no guarantee that disputes would be resolved any quicker if they were handled by VCAT.
VCAT could resolve disputes quicker though, especially because of how informal the process is. At VCAT, the impartial third party generally sits on the same level as the disputing parties and doesn't impose a decision. There are no wigs or robes or strict laws of procedure, and the parties are free to speak freely and come to their own resolution. This benefits disputing parties who have an ongoing relationship. Courts, on the other hand, can be really intimidating places. The parties may feel uncomfortable and might not put forward a good argument.
Formality might be a good thing, Tessa. Informal settings don't work well for disputes where there's a power imbalance between the disputing parties. The powerful party might get their way and the other party would be denied true justice. The presence of a strong third party in a formal setting could help ensure that each party is treated equally.
Good point again, Amani. Maybe we can come to the conclusion that VCAT and courts both have advantages and disadvantages, depending on the situation at hand, which means that we should retain both institutions rather than simply using VCAT for civil disputes. Did you see how we handled that discussion? I would discuss the strength of VCAT, how that compensated for one of the court's weaknesses, and Amani would respond with the strength of the court, discussing how this makes up for the weaknesses of VCAT, and so on, until we had enough of a discussion that we could come to an overall conclusion. This is how you should approach these types of questions. It doesn't really matter how many strengths or weaknesses you bring in, it's the quality of your discussion that will get you a high mark on this question. Thanks for watching and happy studying.